The ANC took its legal battle against uMkhonto Wesizwe Party to the Supreme Court of Appeal. ANC wants its breakaway party to desist from using uMkhonto Wesizwe name and logo.
What 341C does is it protects the goodwill and reputation which vests in well-known marks. And it protects them outside of the scope of confusing use. It protects them against being used for ulterior purposes, in the sense of, not ulterior purposes, being used in a way which takes unfair advantage of those trademarks, or in a way which results in the dilution and disassociation of those trademarks with their rightful proprietor.
uMkhonto Wesizwe Party says the ANC's views on the ownership of the contested marks are misplaced. MKP argues that it attained the name and the logo constitutionally.
The case that we're making in this regard is that whilst it can be accepted that purely on trademarks law, that authorization would have had to be given by the proprietor, that we do accept. But we're saying that as the facts as they are in this matter is such that the MK Party had a mark that it had registered and it has subsequently used. And the usage of that mark, which comes from that registration, cannot be looked at independently.
Well, are you saying that that meant it didn't need authorization?
We didn't need, and that's our submission, we didn't need
that's
justice.
That's the same effectively as saying that it expunged the rights of the ANC to its trademark, at least for the purposes of its application in the political realm.
That is, and I accept that proposition, but the submission in this regard is that as the uMkhonto Wesizwe Party, having used that mark, didn't necessarily expunge the ANC's right to use the mark. But the point that we're making is that as of the time that they decided to abandon their appeal and launched their trademarks claim, they were very much alive to the fact that, in actual fact, the MK Party was using the mark. They knew that. And they knew that the uMkhonto Wesizwe had been using the mark for quite a period of time, even before they launched their trademarks case. So we're saying that the effect of the abandonment and choosing to launch its trademark infringement, right? We're saying that the effect of that abandonment, and endowed with the knowledge that the uMkhonto Wesizwe Party is using the logo, they had in essence waived their right of authorization.
The Liberation Movement says it will do everything in its power to defend its heritage.
My learned friend's point, at least in their heads, is that, well, the ANC may not be able to claim exclusive rights or exclusive ownership of that goodwill because it was not the only person that formed uMkhonto Wesizwe. The Congresses were involved too. And secondly, that organizations such as the SACP, and they list the SACP specifically, the Communist Party, have contributed to that goodwill over time, and they may be able to claim co-ownership or at least a part of those, or an indivisible portion of those rights in due of those rights of goodwill. The short answer to that submission is, as explained in paragraph 34 of our heads of argument, which is that when a person such as the ANC brings a passing off claim, it is not necessary for them to prove an exclusive right to the goodwill that it seeks to protect.
Judgment has been reserved on the matter. For Newzroom Afrika on Channel 405, I'm Ziniko Mhlaba in Bloemfontein.